So, in the late 1800s, many southern states enacted new methods to prevent African Americans from voting after the passage of the 15th Amendment. These included lengthy residency requirements, poll taxes, literacy tests like the one that you guys took in class, property requirements, cumbersome registration procedures, and laws that disenfranchise voters from minor criminal offenses. Grandfather clauses exempted whites from these requirements if their ancestors had voted prior to the 15th Amendment. So if you were a person who their grandfather was able to vote, then that meant that you were also able to vote because you did not have to meet all of these requirements. Of course, if your grandfather had been enslaved, then he would not have been able to vote. Therefore, you would have had to meet all of these requirements, which made it much more difficult for you to register and then actually vote. So again, all of these methods were meant to try to prevent increasing economic power among African Americans. And because of this, Black voting, which had increased obviously for the first time after the passage of the 15th Amendment after the Civil War, now started to decrease towards the end of the 1800s. So the 17th Amendment also is going to change the way that we elect people in the United States. If you guys remember, under the original Constitution, senators were not directly elected. They were selected by state legislators, and that was to create an insulated Senate from tyranny of the majority. But now we elect senators directly. So next year, you guys will be able to actually vote for a senator from our state. This amendment was passed in 1912. And of course, your tip to remember this amendment is 17 senators. 17 senators. Also, the 19th Amendment is going to change voting rights in the United States. As we've talked about previously, some of the Western territories were actually allowing women to vote, because remember, who was eligible to vote is a reserve power, therefore a state-by-state decision. But nationally, women were not allowed to vote. And so in 1919, they did decide to go ahead and add an amendment to the U.S. Constitution, which would guarantee women's suffrage, that a right to vote could not be denied because of your gender. 22 states ratify it, making it a legal right nationally. Also in the 1900s, there were changes to voting rights for African Americans. In the 1920s, 13 northern and western states barred illiterate adults from voting. So as you guys saw from the literacy test that we took in class, all of you would have also been barred from voting had you had to take that test. Many western states prohibited Asians specifically from voting. In 1946, a presidentially appointed National Committee on Civil Rights called for the abolition of poll taxes and for federal action to protect the voting rights of African Americans and Native Americans. Of course, it would be many years before that was actually written into law. At the end of the 1950s, there were 7 southern states that used literacy tests to keep blacks from voting. That included Alabama, Georgia, Louisiana, Mississippi, our home state of North Carolina, South Carolina, and Virginia. 5 states used poll taxes to prevent blacks from registering. Those states were Alabama, Arkansas, Mississippi, Texas, and Virginia. In 1957, a Civil Rights Act was passed. It allowed the Federal Justice Department to review the voting rights issues and file suits against local governments unfairly restricting access to voting. This did successfully increase voter turnout by about 200,000. So if you were in a county where you felt that practices were being used that unfairly discriminated against your access to vote, then you could file a complaint, and the federal government would actually investigate that complaint. So it did successfully increase voter turnout by about 200,000 people. In 1965, January of 1965, the final states ratified the 24th Amendment, which we've also talked about previously, which barred poll taxes in federal elections. So now these states can no longer charge a tax for an individual to register to vote. Therefore, it removes any financial burden that would prevent one from registering to vote. In 1965, at the beginning of that year, only 2% of eligible black voters were registered to vote. Martin Luther King Jr. launched a voter registration drive. The drive lasted 7 weeks. During this time period, nearly 2,000 demonstrators were arrested and put into jail. In March of 1965, they wanted to do a march from Selma to Montgomery, the state capital, there in Alabama, to raise awareness and try to increase support for voting rights for African Americans in the state. The first time they attempted the march, they were stopped by 200 policemen with tear gas, nightsticks, and whips. Everything was caught on cameras and televised nationally, and the rest of the country was mortified at the level of violence that these nonviolent protesters faced. They were unable to finish the march that day, but eventually were able to finish the march some weeks later on March 25th. In August of the same year, the president, LBJ Johnson, signed the Voting Rights Act. This prohibited literacy tests and sent federal examiners to 7 southern states to register black voters. This resulted in the registration of 450,000 southern blacks within just 1 year. So it drastically increased the number of African Americans who were able to vote in those southern states that had legal restrictions on their registration prior to this. And there's an important part of the Voting Rights Act that I want to point out to you, that federal examiners are able to go into these southern states to examine their registration process to make sure that discriminatory practices are not being used. All right, so in your packets, there is an assignment on some of these court cases that we're going to talk about. So if you don't have it out at this time, go ahead and pause the video and take out your packet, and I'll tell you what page to turn to in just a second. All right, so first, if you'll turn to page 13, we're actually going to do 13, 14, and 15 in your packets during this PowerPoint. So there's a lot of words on the screen. You're going to have to read all of them. I will talk you through them, but at any point, if it's necessary, you can pause this video so that everybody has time to write everything down. All right, so the first case that we're going to look at is a case from 1962 in the state of Tennessee. So as I said, I'll wait for a moment to let you read and jot down some notes, and then I'll explain. All right, so the facts of this case. So Charles Baker was someone who lived in Tennessee, and he is going to actually file a lawsuit against the Secretary of State, Joe Carr. Okay, the Secretary of State's job in a state is to oversee elections and the election process. So you guys know, we've talked about before, that states are broken down into districts based on the number of people that they have in the House of Representatives. And so every 10 years after we have a census, the states redraw these districts to reflect the shifts in population. However, at this time, so this is 1962, Tennessee's districts had not been redrawn since 1901. So that was over 60 years of population shifts and changes in society, and the districts had not been redrawn. As a result, the districts were disproportionate in population. The district that Charles Baker lived in was about 10 times the population of some of the more rural districts in the state. And so because of that, 2/3 of Tennessee's representatives were being elected by only 1/3 of the state's population. And so Baker's vote, he lived in a city, was being diluted by other more rural voters in districts where there were fewer people. And so he actually filed a suit in federal district court, but the court did not think they had jurisdiction to rule over state redistricting cases because they thought that that was a state issue, not a federal issue, so they dismissed the case. So Baker appealed the case to the U.S. Supreme Court. So the constitutional question is, does the court have any jurisdiction over questions of legislative apportionment? That just means, can a federal court tell a state that the way they redrew their federal congressional districts was right or not? Or does that have to be done at the state level? So the court decided that they can use the 14th Amendment's Equal Protection Clause to justify their ruling. So they do have authority to rule in the case, and they decided that no state can deny to any person within its jurisdiction the equal protection of the law. Again, if you need to pause the video, you can. So the court's decision, it was a 6-2 decision. They said that the case is justiciable. That means that the court does have authority to rule on this issue. So the lower court should not have thrown the case out. Ultimately, they decided that one man's vote should be equal to any other man's vote. So one man, one vote. One person's vote anywhere in a state should be equitable with any other person in that state. So fundamentally, districts should have about the same number of people per district. If they do not, the word for that is called malapportionment or bad apportionment. If districts don't have the same number of people, then inherently people aren't being represented equally in Congress. And so that means that the district should have been redrawn to reflect the changes in population. There was a dissenting opinion in the case. Justices Frankfurter and Justice Harlan decided that the court did not have the authority to rule on state political processes, and that because this was a state issue, it should have been settled in state court. They thought that the majority in this case, the other 6 justices, were practicing judicial activism as opposed to judicial restraint, meaning that they were legislating from the bench and ruling on stuff that they didn't have the authority to rule on. And they thought that the court was violating the separation of powers, that redistricting should be a legislative issue, not a judicial issue. So why does this case matter? This case is important because this establishes the right of federal courts to review redistricting cases, which had previously been termed political questions, which were outside of the court's jurisdiction. There have been and continue to be many federal lawsuits regarding redistricting across the United States. Our districts, which were originally drawn in 2010, have twice since been ruled unconstitutional, and actually now that's 3 times. They were redrawn in 2010. They've been redrawn twice since then because all of those 3 drawings have been determined to be unconstitutional because they were illegal racial gerrymanders. The court would not have the power to review these redistricting cases if it were not for this case. And actually, courts ruled a couple weeks ago that they have to be redrawn for a 4th time. Yay. All right, so moving on, in the 1900s regarding voting rights, the national voter age is going to be reduced. The war in Vietnam fueled the notion that young people who were young enough to die for their country were old enough to vote. In 1970, as a part of an extension of the Voting Rights Act, which was originally passed in 1965, they lowered the voting age to 18. The Supreme Court ruled that Congress had the power to reduce the voting age only in federal elections, not in state elections. And so in order for us to nationally reduce the voting age to 18, we had to have a constitutional amendment. And so you guys know that the 26th Amendment bars the states from denying a person's right to vote based on age if they are 18 years old or older. Okay, another law that is going to make it easier, hopefully, to register to vote was the National Voter Registration Act of 1993. This was signed into law by Bill Clinton. This is also known as the Motor Voter Act because it allows people to register to vote at the DMV. Many of you have probably already registered to vote when you get your driver's license. You can do that when you are 16 or 17 in North Carolina, and then it would take action once you turn 18. So it allows also for mail-in voter registration provisions so that people can mail in their voter registration forms. All of this makes voter registration easier. So the intent behind this law, and this is a question that is commonly asked on the AP test or on your unit test, is what was the effect of the Motor Voter Act? So the intent behind the law was to increase voter turnout. We've talked about how low our voter turnout is in the United States. The goal of this law was to make it so that more people were actually turning out to vote. If voter registration was too hard, people wouldn't register. So the goal was, let's make it easier so more people turn out to vote. The impact is that voter registration did increase. More people are now registered to vote. So there's a higher rate of registered voters. However, there's not been a noticeable increase in voter turnout. So yes, there are more registered voters, but that does not mean that a higher percent of those registered voters are turning out to vote.